Recognize this? That was the day the Republicans in the House of Representatives were joining the president to celebrate removing the protection that the benefit of no pre-existing condition discrimination provided. Isn't that remarkable?
Otherwise known 2 weeks before he called it a mean bill.
GOP attacking Americans with pre-existing conditions. It's really a riot. At least it should be. Good afternoon. It's afternoon now. I'm pleased to be here with the distinguished Democratic Whip, Mr. Hoyer, and our ranking members of the committees of jurisdiction for maintaining the protections of pre-existing conditions and also addressing the Department of Justice responsibility to defend the law of the land. House Republicans' assault on protections for Americans with pre-existing conditions was one of the cruelest, with stiff competition, mind you, but one of the cruelest parts of their Trump Care legislation. In every district across America, families spoke out with the stories of their loved ones, frightened and angry that the GOP would try to make health coverage completely unaffordable for those in most need of it. And by the way, there were 10,000 events by outside groups, people telling their stories at the time of the discussion of this legislation. Stories like 9-year-old Zoe Madison from Arizona, born with a congenital heart defect, enduring 3 heart surgeries, and a pre-existing condition that will require attention and care for the rest of her life. Story after story. Story like Addie Barkin from California, diagnosed with ALS, but determined to speak out for as long as he can against the threats to health care. He's really a tremendous hero. Any of you have heard him speak know how articulate a messenger he is for everyone with a pre-existing medical condition. Stories like those from Charlie and the Little Lobbyist. You've seen Little Charlie, with her parents, and these little lobbyists with their parents, the beautiful children with complex medical needs whose lives depend on protections for their pre-existing conditions. But Republicans in Congress don't listen. 217 Republicans voted for the monstrosity of Trump Care, which would have demanded key protections for people with pre-existing conditions be dismantled. And last week, Republicans renewed their effort to destroy those vital protections, this time trying to fulfill the cruel vision of Trump Care through the courts. Today, House Democrats are demanding accountability and answers, led by ranking members Pallone, Neal, Scott, Nadler, and Cummings, who's not with us here, but with us in terms of signing the letters. Democrats have written letters requesting documents on the decision-making and analysis that led to this awful assault on people with pre-existing conditions. A letter to HHS and CMS asking for documents. Well, our colleagues will talk about what the letters say. This action in the court is the latest evidence that the Republicans have launched an all-out assault on Americans' health care, especially those with pre-existing medical conditions, and they don't care about who gets hurt. Over the coming months, Democrats will continue to lift up the stories of people impacted by the GOP's health care sabotage and continue to hold Republicans accountable for their awful record on health care. With that, I'm pleased to yield to the distinguished Democratic Whip of the House, Mr. Hoyer. These are the letters. I guess I leave the letters here, no? I'll take the letters. Take the letters with me. Mr. Hoyer.
Thank you very much. Yes, this is the famous race down to the White House. Hurrah, hurrah, we passed a magnificent bill. 2 weeks later, the president, who joined in that celebration, said, I can't support that bill, meaning this bill he was huzzahing about, because it is a mean bill. In fact, they couldn't pass any of their bills because they were all mean. But they continue their stealth attack on the Affordable Care Act and the benefits that it has provided for millions and millions and millions of Americans. The Trump administration efforts to sabotage the Affordable Care Act does not reflect the will of the American people. In a recent NBC News poll, Wall Street Journal poll, more voters and healthcare said healthcare is their top issue over any other issue. Republicans failed to repeal the law in Congress because of popular opposition, not just Democratic opposition in the Senate and the House, but because of the people spoke out. Now they're trying to do so by other means. The ACA can be improved and strengthened. We've all said that. We want to work towards that objective. But the Trump Justice Department would gut the law and would allow insurers to do the following: drop 133 million Americans with pre-existing conditions from coverage. 133 million Americans would not be covered because they may have a pre-existing conditions, including people with asthma, cancer, diabetes, other afflictions. It would allow insurance companies to charge older Americans an age tax, a mean bill. Charge women more than men for the same coverage, a mean bill. And dramatically increase premiums, a mean bill. A mean bill, yes, but mean administrative actions, mean Justice Department actions, mean to our people. Once again, our Republican administration and congressional leadership would say to the American people, if you get sick, you're on your own. Democrats, however, are offering a better deal. We're fighting to improve the ACA, bring down health care costs for families, and take steps to stabilize our health insurance markets. We should be building on the health care reforms we enacted, not tearing them down. Now I want to yield to my friend, the ranking member of the Energy and Commerce Committee, one of the authors of the Affordable Care Act, Frank Pallone of New Jersey. Frank?
First of all, we know that that the Republicans wanted to repeal the Affordable Care Act, tried very hard to do so, and we also know that they continue to sabotage the Affordable Care Act, as does the Trump administration. But what they're doing now with refusing to defend the act in the courts, to me, it's just a new low. I mean, how far does this sabotage go? Do they care at all about whether people have health insurance, whether or not they're able to access health insurance? I mean, they continue to pretend they do, but I think this latest action by the Department of Justice really belies that and shows that they don't care at all. And so one of the things we did is we sent a letter, the four of us, the ranking members, to the HHS secretary and to the CMS administrator, asking to what extent they support this DOJ initiative, and have they looked at the consequences of this DOJ initiative. And of course, yesterday, Secretary Azar said that this was a constitutional and legal position, not a policy position, which sounds like he's just, kicking it down and say, justice can do whatever they please. What we want to know is whether they did any analysis of what the consequences of this action would be if the courts rule and say that pre-existing conditions are not protected and you can discriminate based on that. And what is the impact not only on the individual market within the ACA, but what's the impact on the group market as well? So I don't think we should let Health and Human Services, CMS, get away with saying we have nothing to do with this or this is not our ballpark, because the consequences for the average American are real. If they're in an individual market, if they have private insurance, if they're a group market, whatever happens to be. Now, I want to point out the total hypocrisy of what's happening this week. As you know, on the floor, the Republicans are touting this opiate package, which really doesn't do a lot, right? I would say it doesn't really do much for treatment. It doesn't really do much in terms of helping people recover. But at the same time, they're suggesting with this action with regard to the court case that people who have an opiate problem and need treatment, which is a pre-existing condition, right? That's a pre-existing condition. They're not going to be covered. So whatever you do with opiates, and I'm not saying that all the bills are bad or that we necessarily oppose them, but whatever you do with opiates is going to be meaningless if you have more and more people who have substance abuse problems who can't get insurance because it's not their insurance, or they won't be able to access it because they're going to have to pay so much more. It's just total hypocrisy. And that's the last thing I wanted to mention. What they do with this action and refusing to support the Affordable Care Act in court, all of this is going to drive up costs, right? We know that when they repealed the individual mandate, that more and more people have no insurance, and those left are going to have to pay more. The same thing is going to be true with this, because what I found, my own experience in New Jersey and elsewhere, is whenever there's uncertainty, the insurers just charge more, because they don't know what's going to be covered. They don't know what's going to, what the benefit package is going to be, whether they'll have to cover people with pre-existing conditions or not. And so what do? They put their filings out and they raise prices, they raise premiums because of the uncertainty in the marketplace. And that's exactly what's going to happen here if the Republicans succeed. Premiums will go up, more people will be uninsured, and the consequences that come from that. So now I'd like to yield to our ranking member of the Judiciary Committee, Mr. Nadler.
Thank you very much. For decades, across administrations of both parties, the Department of Justice has held the responsibility to defend federal statutes in federal court, even when the president disagrees with the statute the department is required to defend. At his confirmation hearing, Jeff Sessions, the Attorney General, reaffirmed this commitment. He agreed that federal laws, quote, should be defended vigorously whether or not the Solicitor General agrees with them or not, unless it can't reasonably be defended, unquote. By late last week, the Attorney General abandoned this position, just as he threatens to abandon the millions of Americans with pre-existing conditions who are currently protected under the Affordable Care Act. And the Attorney General's reasoning is deeply, deeply flawed. First, he seems to think that he can walk away from his responsibility to defend this statute in court because President Trump doesn't like the ACA and wants to take another run at repealing its core protections. The Attorney General is wrong. The standard here is whether there is, quote, any reasonable argument, unquote, in defense of these provisions. And if those reasonable arguments can be made, the Department of Justice must step in to make those arguments and defend the constitutionality of the law. For any number of reasonable arguments, I point you to the brief filed by California and 15 other states that have intervened to defend the law where the administration will not. Those briefs are full of reasonable arguments. These arguments are more than reasonable. The courts have upheld these protections for Americans with pre-existing conditions again and again. Second, although there are certainly exceptions to the rule that the Department of Justice must defend the federal statute in federal court, none of those exceptions apply here. Finally, we note that the department's new litigating position is so indefensible that just hours before the filing deadline, 3 of the 4 career attorneys representing the department refused to sign the government's brief and withdrew from the case. Those 3 attorneys represent decades of experience in the civil division. To our knowledge, their last-minute withdrawal is without precedent. Joel McIlvaine, a senior career attorney with more than 20 years of experience in court, has resigned from the department in protest. The one career attorney willing to sign the brief, Daniel Mahler, has worked at the department for only a few weeks. And the senior political official who signed this brief was on the same day, and perhaps this had nothing to do with it, nominated by President Trump for the 6th Circuit. These are not the actions of an independent Department of Justice or an administration that respects the rule of law. My colleagues and I have written the Department of Justice for answers. We will keep at it as long as it takes. We will work to get the information we need to hold these officials accountable for their actions, to help remind the department of its responsibilities, and to make sure that 130 million Americans do not lose their health care because of the president's obsession with repeal. And I'll now yield to the distinguished ranking member of the Ways and Means Committee, Representative Neal.
Thanks, Jerry. I think that part of what you're witnessing here is now a real threat to economic mobility. People, if they feel that they won't be able to take another job because of a pre-existing condition, they're going to stay where they are. So I think that when you look at labor participation rates, this is something that we have to be concerned about as well. This is a threat to 120 million Americans. And for me, as one who helped to write the bill in the Ways and Means Committee, singularly, this is the most popular provision in the ACA. When you talk about this, to audiences, everybody in that room nods in the affirmative. And here's the way to think of this. Without protections as it relates to pre-existing condition, what you're essentially saying is the following: that a child born with diabetes might never be able to secure health insurance, or if they are to secure it, depending on how serious the diabetic case is, that it might be a rating for them securing insurance afterwards. And the other part of this, where we've really made great progress in America, and because of a Democratic impulse in Congress, I might add, this opens the door to an assault on mental health parity. How important was that? Where finally we were able to get insurance companies to treat mental health parity the way they would treat other diseases. It relates, I think, to the whole notion of pre-existing condition. So I'm looking at this and saying, I don't understand why they would pick on this provision, which is universally applauded for the success that we've had. And I hope that going forward, that better sense will prevail. And with that, I'd like to introduce Ranking Member Bobby Scott.
Thank you, Mr. Neal. Congressional Republicans in the Trump administration have relentlessly tried to sabotage the Affordable Care Act. More than a year ago, House Republicans voted for a Trump Care bill that would have caused 23 million Americans to lose their health insurance coverage, increase the costs for everybody else, and resulted in worse insurance coverage than they have now. And in December, while passing a massive tax cut that overwhelmingly benefits corporations and the wealthy, the Republican Congress repealed the individual mandate penalty, which will allow healthy people to leave the insurance market and increase costs for everybody else. The administration cut funding for marketing and outreach efforts. Sick people do not have to be reminded that they need insurance. Healthy people might respond to that outreach, and so cutting funding for outreach will result in an insurance pool that is sicker and therefore more expensive. The administration cut off cost-sharing reduction payments, which caused confusion among consumers, undermined market stability, and increased costs for insurance. It proposed expanding the use of junk insurance plans, where people lose their patient protections. It may be popular amongst some healthy people, but everyone else would be forced to pay higher premiums. The evidence of the administration's sabotage can already be found in New York, Oregon, Maryland, and in my home state of Virginia, where insurers are proposing double-digit increases that they attribute to these initiatives. But the most recent attempt to undermine the law may be the most reckless action to date. By asking a federal court to once again allow insurance companies to charge patients exorbitant premiums and discriminate against the millions of Americans with pre-existing conditions, the Trump administration is demonstrating the extraordinary lengths it will go to take away Americans' access to affordable health care. In filing the brief, the administration abandoned two of its solemn responsibilities. First, the executive branch's constitutional requirement to faithfully execute the laws, and second, its responsibility to act in the best interest of the American people. The administration's stance in this brief lacks any logical or rational legal argument about why the court should make such a radical ruling that would wreak havoc with our health care system. Unfortunately, even if the court rejects the administration's arguments, as it should, this action only injects into the health care system greater uncertainty that will drive up the costs for all Americans. I stand with my Democratic colleagues to call out the administration's irrational attack on patients with pre-existing conditions and one of the most popular patient protection provisions in the Affordable Care Act. Democrats will continue to fight for affordable health care and will demand the administration respect the rule of law. Thank you, and I yield back to our Democratic leader.
I thank our distinguished ranking members for their very impressive statements regarding the unfortunate action taken by the administration to the disadvantage of over 130 million people. That means families in our country. When you see the little lobbyists come, children with disabilities or are born with challenges at birth who have a pre-existing condition for life. And of course, being a woman is considered being a pre-existing condition if you've have any issues that relate to women's health issues, like having a baby, as I have had 5. And they've told me at the insurance company, you're a risk because you've had 5 babies. I said, well, no, I thought I showed my strength by doing that, not my weakness. Any questions on this subject? Yes, ma'am.
Hi, I'm Sarah Hansard with Bloomberg Law. Could you all elaborate on the 130 million? Aren't you including employer people there who
Yes.
were covered before?
Yeah. Well, no, but on that score, the pre-existing condition benefit was a big enhancement for people who are insured because it affected whether they would be employable or if they had someone in their family in that way. Mr. You've addressed this issue about those who have employer-based insurance. What was one of the advantages of the Affordable Care Act is not only that it expanded to over 20 million people who didn't have health insurance, because that was a very important part of it, but what the enhanced benefits that it gave to people with health insurance already. And that included the benefit of removing all doubt about the benefit of pre-existing conditions, being people with pre-existing conditions having access to health care, removing the cap. There was a cap on the coverage that people could have. The list goes on. Mr.
No, on out-of-pocket cost, that was part of the consideration, and I cited a specific example earlier that it was part of incremental change, and the incremental change was a big success story here, and that was called mental health parity, and how people would be able to secure benefits. If you remember, at one time, there was a cap on mental health benefits, that once you got to a certain point, 2 things could happen. Either they could be cut entirely, or the benefit would be reduced. So I use that as an example, and I use the example of diabetes as well. And linking that to employer-based health insurance also, I think, calls into consideration the fact that if you take this away and you have a young person who's got a sickness, and all of a sudden they want to move from Microsoft to Apple, are they going to say, well, I can't, I'm going to keep the lower paid job, because they might treat it differently at the next employer?
Well, and many people that we had heard from in the course of the debate on the legislation said they were job locked. No matter what their credentials, no matter what their experience, no matter their education, or what, again, back to their experience in the field, they were job locked if they had a child with a pre-existing condition or a family member. They simply did not have that mobility, which was unfortunate for their families and unfortunate for our economy.
Well, I mean, look, we've been focusing on pre-existing conditions, but remember, the Republicans during this whole debate kept saying that we were not going to get rid of the patient protections, whether it was, annual limitations on your total cost, lifetime, caps that existed out there, community rating, all these things. They said, oh, we don't want to do it. We're going to keep all those patient protections. It's clear now
And don't forget the maternity.
Yeah, exactly. And it's clear now that they don't care. I mean, that's just, total hypocrisy, because they kept saying they wanted to keep all these patient protections, but now we see that they don't care.
Yes, sir.
Leader, are you going to encourage candidates to run on this court case in the campaign? I mean, do you think this is an effective campaign issue this year?
Well, we'd rather get the issue resolved to the benefit of the American people. That's our purpose. The issue of health care, though, is challenging to the American people because of the unfortunate decisions that the Republicans have made. Their health cost will increase. Put it right down at that doorstep. Secondly, the issue that relates to the cost of prescription drugs is a financial stability issue with people. It's about their health, but it's also, are they able to pay the bills and afford those prescription drugs? The assault that they are making on Medicare and Medicaid is problematic. So it's not a question of what we encourage, it's a question of what people in their lives are threatened by when it comes to their health and the financial stability that is threatened by higher cost of health care. So this isn't about politics. This is about the good health of the American people. And the American people are speaking out as to what they want to hear from people running for office, to hold all of us accountable for how we affect their lives, their health, their financial stability. Any
Well,
comments?
we held hearings when we wrote the Affordable Care Act, and as it's being dissembled, I think that we ought to hold some hearings on these proposals. So I think specifically, the Ways and Means Committee should hold a hearing on the whole notion of pre-existing condition. I'm happy to put the spotlight on it, happy to amplify the discussion, and happy to contrast their position with ours.
Any other questions? Yes, ma'am.
Speaking of the elections, the primary last night, Mark Sanford lost. Do you have any
No, it's.
comment on
No, you'll have
the
to ask,
power of
as the
Trump?
speaker said, you'll have to ask him about that. But we are very pleased at how the primary elections are proceeding. We're very proud of the successes we had in California, New Mexico, Iowa last week, Virginia, as recently as last night, and as returns come in from Maine, which we may not know for a few more days because they have ranked voting. But we're very proud of our candidates. We think we have the A team on the field. They know their purpose, and they know the path to connect to the aspirations and apprehensions of the American people. Thank you all very much. Yes, sir.
Sorry, just one last question. One on this topic and one on North Korea, if that's all right for you, Leader Close. This is for Mr. Nadler. I was wondering if the lawyer in the Justice Department who resigned, if this is someone that you'd be interested in talking to or trying to reach out, if you guys have reached out to this person in any way.
Well, we haven't. We might be interested in talking to him, but I mean, his reason for resigning was crystal clear. This violates all the legal standards. It violates the duty of the Department of Justice to defend the laws. It violates the separation of powers, and he was asked to do what he felt conscientiously he couldn't do.
And I just had a follow-up on the Singapore summit, Leader Pelosi. I was wondering if the president tweeted out this morning that there's no longer a nuclear threat from North Korea. I'm wondering if you feel differently. Have any thoughts on that?
Without saying anything about the president's tweets, let me just talk seriously about what the threat is of North Korea and what the opportunity can be. We all support diplomacy. Talk better than fight. We all agree with that. The challenge that North Korea presents is they are a nuclear state. And the denuclearization of the peninsula has been one of the priorities that was spelled out by all of us, but including the Secretary of State in advance of the meetings. You saw that. So the denuclearization of that certainly has not happened, nor is there any prospect that it will, A. B, the threat of North Korea as a proliferator of weapons of mass destruction is a reality. It happens. And so I don't know if anything has been said in these discussions about the fact that they must stop selling this. When they do their demonstrations, their dog and pony, their launch this, launch that, that's their sales pitch. That's their sales pitch. And that proliferation, I've been to North Korea. I'm one of the few members of Congress who've been to North Korea, and they told us when we were there, when we said, if you want to be in our trade agreements and all the rest, you've got to stop selling these missiles. And they said, well, we don't sell them for any reason but for money. You want to buy them, we'll sell them to you. So they've been proliferating for a long time, and that has to be part of any agreement if we're talking about national security. Stopping the spread of weapons of mass destruction is a pillar of our national security, and it's not anything to be frivolous about. Let's hope for the best in whatever their conversations were. There's nothing in the documents that were signed that would indicate that North Korea is no longer a nuclear threat. I'm concerned of them being a threat as a proliferator. And when you deal with these issues, you have to see what is their capability. We know it's nuclear. What is their proliferating behavior? We've seen the experience. What is their intention as they go forward in both of those areas? These are long-term, serious discussions that have to take place, and you don't just say, well, we're no longer going to do exercises with the South because we no longer see a threat in the North. So, again, we all hope and pray that diplomacy works, for sure. But this is deadly serious. And I guess the one thing I would say is they complained about the Iran agreement. and they have what? You know, they come home with this and say, oh, it's all over. But I'll tell you this, it's a real lesson to any country. If you want to negotiate with Donald Trump, it pays to have a nuclear bomb in your pocket, because that is what will increase your negotiating power. I think we do have to go now, though. Thank you.
Thank you.